Governments are subordinate to the international order. Governments are not autonomous legal entities operating outside the bounds of higher authority. They are subordinate structures, bound by the global legal order rooted in peremptory norms, jus cogens, and codified through international law. Contrary to the myth of sovereign absolutism, a government cannot simply legislate, enforce, or define as it pleases. It is constrained by international legal obligations that supersede national law. These obligations are not theoretical. They are binding and enforceable. The Vienna Convention on the Law of Treaties, Article 27, makes this explicit. A party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. This means no government can use its own domestic legal system as an excuse to ignore its international responsibilities. The state is not supreme. Law is. Similarly, the International Covenant on Civil and Political Rights, ICCPR, Article 2.2, states, where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. This provision compels governments to align their domestic structures with the rights recognized in the covenant, which include non-derogable rights such as freedom of conscience, protection from torture, and recognition before the law. It is not optional. It is a legal obligation. Together, these articles establish that the state is not the source of law. It is a participant under law, and the supreme law, jus cogens, governs all participants equally. A government that disobeys this structure loses its standing. It is not enforcing law. It is violating law, and no title, constitution, or domestic statute can redeem such rebellion. Governments, therefore, must submit to law, not rule over it. Their legitimacy arises from compliance with international standards, and their authority dissolves when they oppose the peremptory norms that bind all lawful power. Governments exist to protect, not control. Governments are not created to control, coerce, or force beings. They are instituted solely for the protection of inalienable rights and the preservation of peremptory norms. Their existence is not an end in itself. It is a functional trust, one that can be lawfully revoked when it turns against the beings it claims to serve. As declared in the Universal Declaration of Human Rights, Preamble, the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Governments, by this standard, are not creators of dignity or freedom. They are obligated protectors. Their mandate begins and ends with preserving the rights that pre-exist all law and statehood. According to the International Covenant on Civil and Political Rights, Article 2.1, each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant. This makes clear that governments have a legal duty to align their laws with the pre-existing rights of beings. It is not a matter of political will or national interest. It is a binding responsibility. Further, the Vienna Convention on the Law of Treaties, Article 53, affirms that any act or law that violates a peremptory norm is null and void. Therefore, any government that engages in coercion, denial of recognition, or suppression of conscience violates the very reason for its existence. The jurisprudence of the International Court of Justice, the Inter-American Court of Human Rights, and the Human Rights Committee has repeatedly upheld this principle. The legitimacy of a government is contingent upon its fidelity to universal human rights. Where a government becomes a mechanism of force rather than a vessel of protection, it ceases to be lawful. It becomes a structure of rebellion, operating outside the moral and legal order it is bound to uphold. Governments exist to guard the being, not to subdue it. When they forget this, they forfeit their legitimacy, and beings of conscience are not only entitled, but obligated to withdraw their recognition. Government violations nullify legal authority. Governments cannot lawfully deny their obligations to beings under international law. When they violate or fail to uphold peremptory norms, they do not merely err, they step outside the bounds of law itself. Their acts become not lawful governance, but systemic rebellion against justice. Peremptory norms, jus cogens, are not subject to domestic interpretation. They bind all states at all times. These include the prohibition of torture, slavery, arbitrary detention, and the right to legal recognition, freedom of conscience, and life itself. Governments are not above international law. Governments are legal entities under obligation, as made clear in Article 27 of the Vienna Convention on the Law of Treaties. A party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. This strips governments of any excuse based on internal statutes. Domestic law cannot override their duty to uphold international obligations, including the ICCPR, UDHR, and customary international law. The duty to respect inalienable rights under the ICCPR, Article 2.1 and 2.2. Each state party undertakes to respect and to ensure to all individuals the rights recognized in the present covenant. Where not already provided for, the state shall take the necessary steps to adopt such laws or other measures as may be necessary. This confirms that failure to align national law with protected rights is not merely a shortcoming, it is a violation of treaty law. These articles impose a dual obligation to respect rights and to actively ensure those rights through effective domestic implementation. This means that if a state party fails to create or revise its domestic laws to comply with the ICCPR, it is automatically in breach. There is no legal waiting period or discretionary timeline. The duty is immediate and non-negotiable. Once the state ratifies the covenant, it must align all its laws, institutions, and enforcement mechanisms accordingly. Failing to do so places the government in default of its international legal obligations. Silence or inaction in domestic law is not neutral. It is a violation. Rights that exist on paper internationally but are not realized locally represent a breach of covenant. The state cannot claim legitimacy or compliance while upholding a legal system that contradicts or ignores the rights enshrined in the ICCPR. Legal consequences of denying inalienable rights. When governments legislate in contradiction to these rights, they nullify their own legitimacy. A government that enforces laws which suppress freedom of conscience, ICCPR Article 18, deny recognition before the law, ICCPR Article 16, or undermine the right to life, ICCPR Article 6, is in direct violation of peremptory norms and thus forfeits any claim to legal governance. A government is not lawful because it claims power or conducts elections. It is lawful only when it obeys the structure of universal justice. When it abandons this, it becomes a violator, not a protector. And beings of conscience are not bound to serve a violator. Governments lose the right to govern the moment they deny the inalienable rights of men and women through the laws they create. Default by failure. Governments and Article 2 of the ICCPR. When a state ratifies the International Covenant on Civil and Political Rights, ICCPR, it enters into a legally binding agreement not only to respect the rights enumerated in the covenant, but also to take affirmative, proactive steps to ensure those rights are effective within its domestic legal order. This obligation is made explicit in Articles 2.1 and 2.2. Article 2.1. Each state party undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant. Article 2.2. Where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. These two provisions together form the implementation clause of the ICCPR. They do not merely suggest that states align with the covenant when convenient. They compel states to ensure that every right recognized in the covenant is legally and practically upheld within their borders. Automatic default through inaction. Failure to translate international obligations into enforceable domestic law constitutes an automatic breach of Article 2.2. This isn't a procedural lapse, it is a legal default. It demonstrates the government's refusal or inability to fulfill its obligations, thus voiding any claim of lawful authority under international human rights law. In legal terms, the government has entered into non-performance of a treaty obligation. International legal doctrine is clear. A treaty-binding state cannot claim ignorance, internal legal barriers, or bureaucratic delay as a justification for non-compliance. Legal doctrine supporting immediate duty. According to the UN Human Rights Committee, General Comment No. 31. The obligations of the covenant are binding on every state party and must be performed in good faith. States parties are required to ensure that all individuals enjoy the rights recognized in the covenant and to adopt legislative, judicial, administrative, educational, and other appropriate measures to fulfill their obligations. This explicitly reaffirms that implementation is not optional, nor may it be indefinitely postponed. It is the legal mechanism through which recognition becomes real. Without it, the state fails in both legal and moral terms. Consequences of breach. A government that fails to implement ICCPR rights in its legal system, fails to uphold the rule of law, violates the principle of pacta sunt servanda, agreements must be kept, operates outside lawful status under international law, becomes a violator of peremptory norms if non-implementation results in continued denial of non-derogable rights. This status is not ambiguous. It is recognized across international courts and legal instruments. States that violate binding human rights obligations do not merely fall short. They forfeit their legal standing in that area. Conclusion. States are not free to selectively implement human rights obligations. ICCPR Article 2.2 imposes an unqualified duty. Governments must align their domestic legal systems with international human rights law. Where this fails to happen, the state is in breach. Where it persists in this failure, it is not a government in law, but a structure in rebellion against the lawful order. In a lawful system, rights are not suggestions. They are binding commands. The being is sovereign, and law must serve that sovereignty, or it ceases to be law. Coerced recognition and the violation of peremptory norms governments violate peremptory norms when they attempt to forcibly reduce the being to a statutory construct, a controlled identity fabricated by the state, imposed through systems of registration, licensing, surveillance, and legal fiction. Such imposition is not neutral. It is an act of coercion that directly contradicts the government's highest legal obligations under international law. This process often begins at birth, when a being is issued a certificate, a document which transitions the human from sovereign existence into a regulated legal subject. From that point, participation in essential systems, health, education, employment, travel, etc., is contingent on the acceptance of a government-assigned identity. These legal identities are tethered to numbers, statuses, and permissions, which replace recognition of the being's essence with recognition of a construct. But peremptory norms recognize the being, not the fiction. Recognition is due by essence, not by registration. Legal frameworks violated by construct, Imposition 1. ICCPR, Article 16. Everyone shall have the right to recognition everywhere as a person before the law. This article affirms recognition must be universal and unconditional. When a government ties recognition to registration or refuses services to those who reject state-imposed identity, it is engaging in unlawful discrimination and denial of legal personhood. 2. ICCPR, Article 18, 1. Everyone shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice. The imposition of identity against the will of the being, especially when that being's conscience rejects such constructs, constitutes a violation of the right to freedom of conscience. It is not merely a legal error. It is a moral crime against being. 3. ICCPR, Article 2, 1 and 2. Governments are obligated to ensure rights without discrimination and to adopt laws that reflect the covenant. Imposing identity constructs that erase moral conscience or make services conditional on submission violates both the obligation to respect and to implement. The nature of the violation. When governments demand recognition of their assigned constructs, they are not honoring being. They are attempting to replace it. The use of force, economic pressure, institutional exclusion, and legal penalties to compel compliance with statutory identity is a form of structural coercion and a breach of jus cogens. This practice effectively dehumanizes beings by subordinating their conscience to a legal mask. It denies the truth that law must arise from recognition of the being, not from registration or classification. Governments that enforce identity by coercion are not operating within the rule of law. They are in rebellion against the order they claim to uphold. Any system that denies beings the right to recognition by essence and substitutes it with forced constructs is a violator of peremptory norms. Such governments cannot be called lawful. They are usurpers of dignity, suppressors of conscience, and enemies of universal recognition. And beings of conscience are neither bound to obey nor morally obligated to comply with such systems. Recognition is not a license, it is a right, and no construct can override the law of being. No construct can override the law of being. There exists no state, statute, contract, system, or structure that can override the law of being. The dignity, awareness, and moral conscience of a being are not subordinate to government recognition, legal status, or institutional decree. They exist before law and form the very basis of lawful recognition. To be is to be recognized. And recognition, authentic, unconditioned recognition, arises from awareness, not from registration. Every attempt to condition legal standing on paperwork, identity constructs, or systemic classification is a violation of that truth. A construct, whether it be a government-issued identity, a citizenship status, or a social role, is a fiction. It is a tool, created by systems to manage populations, not to define existence. And when these tools presume to replace the being, they become instruments of suppression. The law of being is peremptory. It is jus cogens, a norm so fundamental that no agreement, treaty, or law may override it. The right to recognition as a person before the law, ICCPR, Article 16. The right to freedom of conscience, Article 18. And the right to be free from non-consensual jurisdiction, Vienna Convention, Article 27, all affirm this principle. The illegitimacy of imposed constructs. Governments that compel beings to accept imposed identities are in rebellion against the foundational order of law. These systems replace inherent recognition with conditional permission. This is not governance. It is usurpation. You are not your ID number. You are not your legal status. You are not your registration. You are a conscious being, and that is the highest lawful identity possible. Conclusion. No construct, no matter how widely accepted or legally enforced, can override the truth of the being. Law must conform to the being, not the other way around. Recognition is not earned through systems. It is affirmed through awareness. The law of being is the beginning and end of all true authority. Essence is not negotiable. Recognition is not a contract. Law must bow to the being, or it is not law. Why present government structures cannot stand. Present. Government structures are collapsing under the weight of their own contradictions. They are not being toppled from without. They are dissolving from within. This is not political theory. It is legal reality. The collapse is the inevitable consequence of persistent violations of peremptory norms and the abandonment of their foundational obligations. Governments that enforce systems of coercion, deny recognition of conscience, condition rights on legal identity, and legislate against the dignity of being are not sovereign bodies. They are unlawful constructs, violating the core of legal authority. International law is clear. A government's authority does not arise from control, elections, or historical continuity. It arises from compliance with universal obligations, particularly those found in Vienna Convention on the Law of Treaties, Articles 27 and 53. Domestic law cannot justify treaty breaches. Any law in conflict with peremptory norms is void. ICCPR, Articles 2, 16, 18. Governments must respect and ensure inalienable rights, including recognition before the law and freedom of conscience. Universal Declaration of Human Rights. Preamble. Affirms that dignity and rights are inherent and must be protected. When governments legislate in defiance of these norms, they are not lawful participants in the international order. They are in rebellion against it. The principle of forfeiture. Lawful authority is not permanent. It is conditional, and that condition is fidelity to the foundational norms of justice. When violated, those norms strip the violator of legitimacy. The doctrine of forfeiture of legal standing is supported by ICJ and ICCPR jurisprudence, confirming that systematic human rights violations negate lawful authority. The principle of erga omnes obligations, where duties are owed to all and violations are actionable regardless of borders. Why these structures will not endure. Systems that deny essence and substitute control for recognition cannot stand because they contradict the moral conscience of the being and thus provoke lawful resistance. They collapse under the illegitimacy of their own law, enacting void statutes that cannot be enforced without coercion. They rebel against the source of all law, the conscious being. No system built on fiction, imposition, and denial of dignity can endure. The foundation is sand, and peremptory norms are the rising tide. The structures that violate their own obligations are not failing by accident. They are collapsing as a matter of law, and beings of conscience are not witnessing chaos. They are witnessing judgment. The law that cannot be broken, the law of being, is the verdict, and it is final. The ICCPR Preamble and Government Accountability for Global Injustice. The preamble of the International Covenant on Civil and Political Rights, ICCPR, teaches that the recognition of the inherent dignity and the inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. This statement is not poetic. It is a legal standard and a declaration of truth. Governments who ratify the ICCPR are not merely endorsing ideals. They are binding themselves to a code of action rooted in conscience, law, and justice. Yet today's governments, by their repeated and systemic refusal to uphold these obligations, stand as the primary architects of global disorder. It is not the beings who have failed the world. It is the governing systems that have violated the foundation they were sworn to uphold. The preamble of the ICCPR, recognizing that these rights derive from the inherent dignity of the human person, recognizing that in accordance with the Universal Declaration of Human Rights, the ideal of free human beings enjoying civil and political freedom can only be achieved if conditions are created whereby everyone may enjoy his civil and political rights, as well as his economic, social, and cultural rights. Governments that ratify this covenant promise to create those conditions. They promise to respect and enforce rights as pre-existing, derived from the being's essence, not from law, registration, or permission. And yet, we find that most of the world's governments deny those very conditions. They refuse to recognize the conscience of beings who reject imposed identities. They condition access to rights and services on submission to control. They fail to implement domestic laws required by Article 2 of the ICCPR. They suppress freedoms of speech, belief, and movement, violating Articles 18, 19, and 21. These are not technical failures. They are structural betrayals of the ICCPR's preamble, the very mission they pledged to uphold. The consequence: governments are the source of crisis. It is the governing systems, not the human conscience, that are responsible for the erosion of peace, the degradation of the environment, the collapse of trust, the institutionalization of inequality, and the global climate of despair, division, and surveillance. Beings are blamed, criminalized, and disciplined for resisting domination. But they resist not chaos. They resist violation. The truth is inverted. Those in power accuse the aware of disorder, when it is their denial of dignity that produces disorder. Legal failure is moral failure. Governments are not failing in service delivery alone. They are failing in moral structure. By abandoning their obligations under peremptory norms, especially the recognition of the inherent dignity of every being, they have become unfit to govern. The ICCPR's preamble foresaw this, that where dignity is denied, there can be no peace, no justice, and no freedom. The present condition of our societies and our planet is not a mystery. It is the direct outcome of decades of state-level betrayal of the law of being. Conclusion: the world is not in crisis because conscience failed. It is in crisis because governments did. They did not create the conditions they were obligated to uphold. They replaced recognition with registration, dignity with control, freedom with compliance. And in doing so, they dismantled the foundation of lawful order. The beings are not the problem. The governments that denied the beings are. And the remedy is not reform from within a failed structure, but recognition of what was always true, that dignity, conscience, and being are the true governors of this world, and any system that violates them will collapse under its own illegitimacy.